Virginia has a well-structured lease termination framework that gives landlords clear procedures to follow while still providing meaningful protections for tenants. The governing law is the Virginia Residential Landlord and Tenant Act, Virginia Code Title 55.1, Chapter 12, and it lays out the termination process with specificity that makes compliance straightforward if you pay attention to the details. Let's start with no-cause termination. For month-to-month tenancies, Virginia requires either party to provide at least 30 days written notice before the next rent due date. So if rent is due on the 1st and you want the tenancy to end on the last day of the following month, you need to deliver notice at least 30 days before the next rent due date. The notice must be in writing and should clearly state the date the tenancy will end. For fixed-term leases, the lease expires at the end of the agreed term without requiring additional notice unless the lease itself specifies otherwise. If the tenant remains in possession after the term expires and the landlord accepts rent, the tenancy converts to a month-to-month arrangement under the same terms. To avoid this automatic conversion, landlords should send clear written notice before the lease expires. For week-to-week tenancies, 7 days' notice is required from either party. Now let's cover termination for cause, and Virginia provides landlords with a structured set of tools. For non-payment of rent, Virginia has a specific process. The landlord must provide a 5-day pay or quit notice under Section 55.1-1245. This notice gives the tenant 5 days to pay the full amount of rent owed. If the tenant pays within the 5-day window, the notice is void and the tenancy continues. If the tenant doesn't pay, the landlord can proceed with filing an unlawful detainer action in General District Court. Here's something important about Virginia's non-payment process. The state has what's called a right of redemption. Even after the 5-day notice expires and the landlord files for eviction, the tenant can still pay the full amount owed, including any late fees and court costs, and stop the eviction. However, this right of redemption can only be exercised once in any 12-month period. After the tenant has used it once, the landlord is not required to accept a late cure for the next 12 months. This provision balances tenant protection with landlord interests by preventing tenants from chronically paying late and using the redemption right repeatedly. For lease violations other than non-payment, Virginia uses a 21-day notice to cure, followed by a 30-day termination timeline. Under Section 55.1-1245, the landlord must provide written notice specifying the violation and stating that the rental agreement will terminate in not less than 30 days if the violation is not remedied within 21 days. If the tenant corrects the violation within 21 days, the notice is void. If the tenant doesn't cure within 21 days, the tenancy terminates at the end of the 30-day period, and the landlord can file for eviction. For repeated violations of the same lease provision, Virginia has a specific escalation process. If the tenant commits the same violation a second time within 6 months of receiving a prior notice, the landlord can issue a new notice, giving the tenant 21 days to cure. But this time, the notice can also state that the lease will terminate if the same violation occurs again within the next 6 months. On the third occurrence within that window, the landlord can terminate the lease with 30 days' notice without offering another opportunity to cure. For serious criminal violations, Virginia provides a faster pathway. If a tenant, authorized occupant, or guest commits a criminal act that poses a threat to health or safety, including drug offenses, violent crimes, or criminal activity that threatens other residents, the landlord can terminate the rental agreement immediately by providing written notice that the tenancy will end in not less than 30 days. Virginia also addresses specific situations involving illegal drug manufacture. If a tenant is manufacturing or distributing controlled substances on the premises, the landlord can terminate the lease immediately and pursue eviction without waiting for the standard notice period to expire. On the tenant side, Virginia provides several grounds for early termination. Tenants who are victims of family abuse, Virginia's term for domestic violence, can terminate the lease early under Section 55.1 to 1236. The tenant must provide written notice at least 30 days before the termination date and include documentation such as a protective order issued within the preceding 30 days or a conviction of the abuser. The tenant is responsible for rent through the termination date, but is not liable for any early termination penalties. Virginia also provides early termination rights for tenants who need to enter an assisted living facility or other long-term care. The tenant or their legal representative must provide 60 days written notice, along with documentation of the medical need for relocation. Active duty military members are covered by the Federal Service Members Civil Relief Act, with the standard 30-day notice following deployment or permanent change of station orders. Virginia also has its own state military protections that complement the federal law. Virginia tenants can also terminate if the landlord fails to maintain the property in habitable condition. As we covered in our Virginia habitability video, the tenant must follow proper notice procedures and allow the landlord time to make repairs before exercising the right to terminate. One area where Virginia has gotten more detailed in recent years is the landlord's obligations during the termination process regarding personal property. If a tenant leaves belongings behind after vacating, whether voluntarily or after an eviction, the landlord must follow specific procedures for handling the abandoned property. Virginia law requires the landlord to give written notice to the tenant that they have a specified period to retrieve their belongings before the landlord can dispose of them. Failure to follow these procedures can result in liability. Virginia strictly prohibits self-help evictions. Landlords cannot change locks, shut off utilities, remove doors or windows, or remove the tenant's belongings. All evictions must go through the General District Court. Landlords who engage in self-help eviction can be liable for actual damages, attorney's fees, and a civil penalty. The eviction process in Virginia goes through the General District Court. The process is relatively efficient compared to many states. Once the landlord files an unlawful detainer action and the tenant is served, a hearing is typically scheduled within a few weeks. If the court rules in the landlord's favor, a writ of possession is issued, and the sheriff executes the eviction. The total timeline from filing to removal is often 4 to 6 weeks in straightforward cases. Virginia also requires landlords to return the security deposit within 45 days of the tenant's departure, or provide an itemized list of deductions. This deadline applies regardless of whether the tenancy ended voluntarily or through eviction. Failure to comply within the 45-day window can result in the landlord being liable for the full amount of the deposit plus penalties. For the complete guide to Virginia lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our series.